Good afternoon, and thank you for joining us for the Ezra Digital 2021 Education Series. Welcome to today's webinar, ESIGN Day 2021. My name is Mallory, and I will be your Ezra moderator. Before we get started, there are a few items we need to go over so you get the most out of your participation in today's event. All attendees have been muted for this presentation, and we will be recording this presentation for later viewing. Our speakers today are Steve Bisbee, Jerry Buckley, Ken Moyle, Margot Tank, and David Whitaker. They were all involved in advocating for the original ESIGN bill in 2000 and championed for the recognition of a National ESIGN Day on the 10th anniversary on June 30th, 2010. Steve Bisbee is the founder and president of eOriginal, Inc., a leading provider of digital transaction management solutions and financial services. Jerry Buckley is a founding partner of Buckley LLP, who in his 40-year career has established himself as an acknowledged leader in financial services law. Ken Moyle is the managing director of K6 Partners and is a licensed attorney and subject matter expert in all facets of digital transformation. Margot Tank is a partner at DLA Piper LLP and has been helping companies with digital transformation for over 20 years. David Whitaker is also a partner at DLA Piper LLP, where he advises traditional and emerging financial services companies and commercial enterprises in transactional, legal, and regulatory matters. Please welcome Ken, Steve, Jerry, Margot, and David.
And thank you, Mallory. It's a pleasure to be here today, and we're all very happy to be celebrating the 21st anniversary of the passage of the ESIGN Act. We're going to take a short look back at this historic legislation, consider the vital role it played during the COVID crisis, and look at some potential changes in law to bring it up to date in the period that has elapsed over the last 20 years. The Federal ESIGN Act has proven to be remarkably durable, and its usefulness during the pandemic was central to preserving large parts of our commerce in the United States. So how did the ESIGN Act come about? ESIGN actually had its origins in an initiative by what was then called the National Association of Commissioners on Uniform State Laws, or NACUSL, now known as the Uniform Law Commission, which had produced such important uniform laws as the Uniform Commercial Code, or the UCC. That body, realizing the benefits of clarifying the role of electronic signatures in what was then a newly blossoming digital economy, gathered state officials, academics, and legal practitioners, including one on this call, David Whitaker, into an effort to create a e-signature law, which emerged as the Uniform Electronic Transactions Act, or the UETA. But despite the high hopes for this legislation, it soon became apparent that getting it enacted uniformly was going to be difficult and wasn't going to happen. The first state to take it up, California, and at the urging of some activists who claimed that they were interested in protecting consumers, the California legislature excluded consumer transactions from the scope of the act. It then became apparent that if a law were to be uniform across the nation and were to be enacted, which of course was necessary because the internet is a borderless medium, would have to happen at the federal level. And that is where some of us got into the act. We organized the Electronic Financial Services Council, a predecessor to ESRA, and worked with members of the House and Senate to get the ESIGN Act through. This was not an easy task. The same activists who opposed the California inclusion of consumers opposed the ESIGN Act, and they were joined by many in Congress and the Clinton administration, which threatened a veto of the bill. Only when we were able to secure the support of then Congressman Jay Inslee and the New Democrat coalition will be able to put together the coalition that got this legislation across the the goal line. And in fact, President Clinton, who had threatened to veto, signed it with great ceremony in Philadelphia. What emerged was a compromise with protections built in for consumers. The principal characteristic of the bill is that it is an overlay statute impacting transactions across the board with only a few exceptions. It basically makes electronic signature the equivalent of a wet signature, an electronic record the equivalent of a paper record. The statute also has a unique reverse preemption provision that says that ESIGN will prevail, but if a state adopts the UETA as reported by McCusill, ESIGN will defer to the UETA. The statute also is interesting in that it does not provide for any regulator or the promulgation of regulations. And that was deliberate because the intention was that we not ossify in regulations, which are hard to change, rules that might have to be flexible in a time when technology was moving quickly. So we don't have a regulator, and the lack of a regulator was a little bit of a hindrance because there was no guidance as to the details of how one was to do this transaction, which was now authorized by law. In response to that, we organized something called SPURS, the Standards and Procedures for Electronic Records and Signatures, an effort that took a year and a half and involved many leading companies and trade associations. But what emerged was a series of guidances to what was expected and what the terms meant when you talked about authentication or the signature process and so forth. And that guidance has proven also to be very durable, and in fact resulted in the auto industry, the mortgage finance industry, the insurance industry, and others adopting SPURS as the core of the guidelines for their industries. And the whole purpose of it was to, you and I could enter into a transaction and it would be binding between us, but how does a third party, someone buying a mortgage on the secondary market, know that that was done properly? And so if they can make a certification that they complied with the standards and SPURS, that can give the market confidence and create a common language. In addition, Margot and David and I are authors of a book which we published, The Law of Electronic Signatures and Records, published by West Publishing Company, to try to, again, give the legal profession and the market some sense of what is intended by this law and how it is intended to be effective. And that's revised every year. In fact, we're struggling with getting the revision for this year done, as Margot and David will tell you, but we get it out every year. And it keeps up with what's happening in the law in this area. Now, I referenced the fact that the COVID crisis has really given, was made less onerous by the presence of ESIGN. And there's no one on this call who didn't experience more of that than our colleague, Steve Bisbee, who at eOriginal experienced an enormous surge of business as ESIGN was taken up. Steve, could you share with our audience your experience and the role that ESIGN played in effectuating the PPP program and other government and private activity during that period of time, this period of time?
Thank you, Jerry. So there's a saying, and it was in, maybe it was on Fox News, but they said that 2020 gave rise to the adoption of digital everywhere. But it didn't initially. We really didn't know what was going to happen when COVID came and how we were going to be able to react. The foundation of having these statutes in place really enabled things to move so quickly, and I'll make mention of what Jerry referred to with the PPP loans. But Connie Hunter, who is the chief economist for KPMG, said that the pandemic shocked the economy in general to adopting technology, and that we're going to see a continued investment in productivity enhancing technology because the pandemic made it clear that we're going to need to have this digital backbone. And others in the group today will talk about how this is continuing and how it's affecting Even as we seem to maybe move somewhat beyond where we were, obviously a year ago, but with the pandemic and looking at back to office. But in American Bankers Association noted that in 2020, there was a 44% digital transaction growth globally to $4 trillion. And we at the original saw this in particular because of the rise of digital assets that needed to be created to maintain the economy and getting out into the secondary market. In the pre-COVID world, when we were all of us that are on this in this webinar today, we were doing basically a push. We were trying to move people in. How do we move the barriers to digital adoption? We were focused on the borrower experience, Ken, and what happened, what he did with DocuSign. Then the need for capital efficiency. How do you make the process more attractive to the secondary market and investors? How do you reduce the cost, which has always been a primary issue in digital adoption? But it wasn't until COVID hit and everyone realized they weren't going to be able to be with others. Their offices were going to be closed. It was not available to do closings, go to your bank for your mortgage or to your dealership for your car. And we really had to make an enormous effort across our economy to be able to do remote closings. And Dave's going to speak a little bit about remote online notarization and how those statutes really came into play and how these are going to outlast this, the initial impact of the epidemic. But with all of these, we ended up having to focus on having remote and contactless digital transactions. And these were all enabled because we had ESIGN and UEDA in place. Jerry mentioned the fact that the SBA, so the SBA PPP loan program, when you went into the SBA regulations, which not many people had paid much attention to until this crisis, they had in the legislation the references to ESIGN and UEDA and what the rules of the road were going to be for those PPP loans. If those rules of the road had not been in place, we would not have been able to act so quickly to get the money out into the PPP programs. We had a number of folks who are involved with Ezra today in terms of remote closings for mortgage, remote closing rooms, the remote notarization that really enabled the mortgage industry to continue, though we did have sort of drive-by and parking lot closings as well. But in the automotive world, where we have a lot of activity in the original, they had to be able to move those closing out of the dealership and directly to the consumer. And that changed for our clients like Tesla and Carvana and CarMax and others. That has not only become effective within 90 days, which is truly astounding, that is going to be the way that we continue to do business. The national associations have basically said that, in Cox Communications said that 73% of the dealers say they're not going back. That their business is going to remain being able to reach out to the consumers digitally, and even to the point of having your cars delivered to you and maintained. So with these tools in place, being able to go remote, being able to go contactless, being able to have back office operations also. A lot of the companies, national and international companies, were able to go 100% remote in a matter of weeks because they have been prepared through business continuity programs. And they were, it was a struggle, but the economy actually in the digital world increased enormously over the course of the last year. And so, David, do you want to talk a little bit about your examples in terms of notarization?
Sure. Years ago, I worked with an attorney who had been intimately involved in the creation of one of the first fiber optic cable networks across the United States. And he used to like to talk about the fact that getting the cable transmission lines in place from one city to another was, with respect to 99% of the distance involved, simple. And then there was what he called the last mile, getting the fiber optics into the last mile. And in the world of electronic commerce, in a lot of ways, notarization has represented the virtual equivalent of the last mile. trying to get to the point where not only can we do commercial and consumer transactions electronically that do not require acknowledged or notarized documentation, but getting to the point where we can do those transactions that do require notarization electronically as well. The ESIGN and UETA kind of set the groundwork because they enabled electronic notarization in the sense of eliminating stamp and seal requirements. It's basically saying you don't need to have a stamp, you don't need to have a seal. You do need to include that information that would have appeared on the stamp and seal, but you don't need to have the stamp and seal. And yes, the notary can execute the acknowledgement electronically. But ESIGN and UETA were very, very careful to make clear in words pretty much of one syllable that they weren't doing a darn thing about the in-person requirement. In-person requirements were going to stay in place. So I might very well, as a notary, electronically notarize your document, but only if I was standing over your shoulder looking while you were signing the document. Of course, we knew prior to COVID that this was an obstacle and it needed to change, and it had started to change. Virginia pretty much startled everybody in 2012 by saying, oh, to heck with this. And they put in place a remote notarization statute. But other states were slow to follow. There were a few that followed before last year. But then COVID hit. And all at once, folks were not enthused about having someone else stand over their shoulder and watch while they signed things because they were also breathing over their shoulder at the same time. And a lot of folks, including a lot of legislators, suddenly became very intrigued with the notion of letting folks do that electronically. The upshot is today we have 34 states with permanent, true remote online notarization statutes, and a few others that have COVID orders in place or have kind of strange one-off kind of mutant remote notarization statutes in place that do pieces of remote online notarization, but not quite all of it. But all of them are trying to get us to the same place, which is that I may appear as I do now in front of you on a virtual screen, prove who I am, probably more effectively than I would if I were appearing in person, and then sign the documents, have you notarize the document electronically, and all of that is recorded in a way and memorialized in a way that is also probably more effective and more convincing than the processes that are being used historically with respect to notarization. This all then becomes part of the larger drive to digital transformation we're seeing today that we're going to talk about at some length a little later in the presentation. But we are still encountering a lot of friction. And some of that friction is in remote online notarization. And perhaps today, one of the biggest issues is, yeah, we got 34 states with 34 statutes, and boy, do we have 34 statutes. We got 34 statutes that don't look anything like each other because Arkansas hates Texas and Texas hates Illinois and Illinois hates Virginia and everybody hates Washington, D.C. So the upshot is that we're trying to work our way through right now as a country. What does that mean when every state has slightly different standards for RON? If I'm going to execute a document for recording in California, do I have to meet the California standard? Or if the notary's in Virginia, can I meet the notary standard in Virginia instead of having to meet the California standard? And how does the California Secretary of State feel about that? And does the California Secretary of State even get a vote? Because actually all they're supposed to be doing is regulating their own notaries, not regulating what's accepted down at the county courthouse. Meanwhile, the people at the county courthouse might think they've got a vote on the subject, while the Attorney General of the state might think they don't. And so that's why we're still trying to figure out online notarization. But there are other things that are kind of getting in the way a little bit too, and Margot is going to talk a little bit about those.
Thanks. As you can see, the digital everywhere, the attempt that we're all representing from different locations, and hopefully we'll be able to continue to do that. There's the one.
I think that I want to just say, Margot, your background in Nantucket is probably the best on the call.
There you go. There you go. So to David's point, we're one step forward, one step backward. We've been saying that ESIGN as enacted and UITA as promulgated and set forth for adoption 1998 and 2000, that they were the gating issue, and that, oh wow, digital was going to break open and everyone would move forward into the use of electronic signatures and records. And here we are, celebrating ESIGN, celebrating National ESIGN Day, but also recognizing that it's still a little bit of a battle of hearts and minds, and a few other aspects. So not to, put a damper on all the positivity that's happened in the last 21 years, but just let's talk a little bit about some of the reasons for slow adoption. There has been a lack of industry consensus regarding the core components of a paperless transaction. There's questions, and it's a cycle that's happened over 21 years about building or buying technology to facilitate the core components. Little or no regulatory or judicial guidance, and we'll talk about in a bit how that's absolutely changing for the better. There's been sort of fits and starts about industry participants not perceiving the benefits of being first to market with innovative practices and taking risks, because the regulators have been fairly silent, and the courts, while they have been addressing these issues, the guidance comparatively to other types of guidance is still minimal, especially for the more complex transactions. Jerry mentioned SPURS, which which has been in existence since 2003, which is a great sort of basic guideline. Trade associations and industries are starting to adopt, but what happens is that every industry doesn't really understand the sort of generic approach to the components of SPURS, and wants to get very specific and adopt standards for their own industry. And that may be a good idea, but that also leads to slower than anticipated adoption rate. Resources, just the amount of time and effort that it takes to move a process digitally. Limits on technology platform interoperability and integration, expense moving legacy systems online, statutory complexity, and everyone's slumping their shoulders at this point saying, yes, oh, that sounds like difficult to overcome all of these issues, but we've come an incredibly long way, and we still have further to go. But the statutory complexity, and to David's point, the RON laws have illustrated why we had ESIGN to begin with, because the thought was that states would adopt the UETA and tweak it, and that internet is borderless. So how would we have commercial transactions seamlessly and efficiently if every state was enacting their own version of the UETA? And that's definitely happening with remote online notarization. So, again, it's the one step forward, which is fantastic that we don't need to be in person, and notarization, the last bastion, and e-recording for certain types of transactions is actually happening. The complexity is that the statutes are varying and not uniform. Data security, and I know Jerry might talk a little further about that, but it's also still a remaining pain point that is going to need to be addressed and attention paid, because digital is all about data, and the more data that's online, the more secure that it needs to be. And then finally, part of the passage, the price for the passage of the ESIGN Act was a provision that's known now as 101C of ESIGN, and it's the consumer consent provisions. And what it means is that ESIGN and the UETA are opt-in statutes that all parties have to agree to transact business electronically. ESIGN has a very, very specific provision in Section 101C that requires affirmative consent from the consumer to be able to replace paper records with electronic ones, but also includes a variety of disclosures related to the transaction, the scope of the transaction, whether you're going to charge a fee for a paper copy, how to withdraw consent, the hardware and software necessary to be able to view and retain the transaction, all seemingly, interesting and necessary at the time, 20 years ago, when the digital divide and the internet was, or the fear of the digital divide and the sort of unknown nature of how the internet was really going to be utilized and lack of comfort using it, the consumer consent provisions made a ton of sense. Part of the requirement is that the process needs to reasonably demonstrate that the consumer can actually access and retain the information. Well, this has caused a lot of friction. So I'm adding it to the list of pain points that still exist. There are companies that very much worry about how, without any regulatory guidance, to really understand what's required, because the consequence of not complying with 101C can be significant. If you have, just for example, a mortgage transaction and you don't get proper consent, then the truth in lending disclosure that you're providing as part of the transaction could technically be deemed to be not, delivered. We haven't had any case law on this, but the consequences, as I said, are significant. So a big friction point that we hear about all, and there's been a movement afoot to amend this section of the ESIGN Act, and it may finally have its day in Congress. And I'm going to turn it to Ken, who is our ESRA's public policy chair, to talk a little bit further about the ESIGN amendment and what it means and ESRA's role.
Thanks, Margot. As you said, the framework here is simply that ESIGN has really, for the most part, withstood the test of time. The fact that it's an overlay statute, the fact that there's no regulatory body, the fact that we have, left it to be able to be interpreted under the present technological environment rather than the past technological environment has really given it legs. And so ESRA has been extremely defensive of cracking open ESIGN and having it changed for one reason or another. An example of that is recent. Over the past few years, we've combated, from a public policy standpoint, attempts to amend both state laws and the federal ESIGN Act to somehow take a new concept like blockchain and create a new definition for it, or a new category for it within all of these statutes. And really, by virtue of introducing that concept, chipping away at the technology neutrality of statutes and really causing much more confusion than is necessary based upon confusion about that technology itself. As when we look back at these attempts, we'll see that it's simply a new technology that folds perfectly well into ESIGN and the UETA. So with that in mind, we've been very defensive about really opening up a Pandora's box by trying to make people trying to make amendments to ESIGN that may or may not help. But as Margot said, ESIGN right now includes a provision that requires the affirmative consent of a consumer when entering into electronic transactions, and that's such as even receiving a required disclosure or signing an online agreement. And in the early days of the internet, back in the 90s, when the law was being drafted, there were pretty much legitimate concerns that many consumers did not understand electronic transactions, did not have the hardware, software, or general technical acumen to know what they were being asked to do. And so folks stepped up to basically protect them. But in response to that concern, as Margot and Jerry both said, the statute went much further and now required that consumers express consent in what they say a manner that reasonably demonstrates their capacity to conduct business electronically. Now, this is one part of the statute that's gotten pretty stale. This one provision is, as Margot said, created a lot of friction for consumer transactions because the consumer will not be able to participate in a transaction unless they can prove somehow that they're capable of, say, I don't know, opening up a PDF file or something like that. And again, that was probably something that was legitimate 21 years ago, but again, it doesn't bear truth today. So ESRA back in 2020, when an amendment was to ESIGN was proposed, for the first time, we came out and actually supported an attempt to modify and change that component of the ESIGN Act. Senator Thune at the time, back in almost exactly a year ago, introduced it to Congress, a bill that would make minor modifications to make the reasonable demonstration component sort of evaporate and have the demonstration be basically self-proving within a transaction to make it more modern and more akin to what people actually do today, with the idea that we're empowering consumers to do transactions the way they want to do them rather than the way they must do them under current views of the law. So that bill, we sent an actual letter of support again for the first time to say, yeah, you know what, this is surgical. This is something that actually probably needs to be done. We're all for it. That died in committee, but it was reintroduced this year, again by Senator Thune. And we have been working with the folks drafting the draft language to assist in, as ESRA always does, in giving some historical background as well as some drafting hints on how to be, again, surgical and specific to the problem without creating more problems, which always happens when you try to amend legislation.
I think it's important to note that the opt-in nature of the consumer consent provision, would still exist. That is based on a premise that there's a right to paper. Somehow, maybe 20 more years from now, that premise will disappear. That you don't have a right to paper, you have a right to information. But for right now, it keeps that same opt-in structure, but does make the process more consistent with the global approach. So most laws in most countries have a parallel structure to ESIGN, and all have an opt-in nature, but do not have this elaborate consent that's included in 101C. So any move to refine that would be helpful for companies.
Right. Yes, that's true. And again, we've been ESRA as a organization has been assisting and using the history that's clearly, all the folks on this call with the history and knowledge that they have, helping to inform the legislation and also prepare the drafters and the supporters and the introducers of the bill, sponsors of the bill, to understand what the consequences may be of touching any of those provisions and being able to prepare and defend the bill against any of those concerns. I wanted to get back, Margot, to the concept of blockchain. I touched on it briefly about, these are the types of rules, or I guess the introduction of the bills that we saw tried to create a definition structure around blockchain that we determined to be unnecessary, which is a smart contract is a contract, a blockchain signature is a signature. The things that actually range anywhere from unnecessary to just plain incorrect. And it's based usually upon technological inexperience or lack of full knowledge of what blockchain technology is.
Yeah.
But I think you and I have dealt from a public policy perspective, kind of defending ESIGN and UEDA against those things. But there are things that blockchain introduces on the whole concept of blockchain as a tool for authenticating documents and creating a regime for authenticating digital material that actually is becoming quite relevant. Just want your thoughts on that. I know you've been dealing a lot with that as well.
Sure. Just quickly, we're celebrating ESIGN and UETA, and one of the things to celebrate and to note is that they were written with a technology neutral approach, over 20 years ago, that included the idea of a definition of an electronic agent, which is defined as essentially enabling contract to be formed by the interaction of agents, even if no individual or no individuals involved. So computer to computer discussion. And I think the foresight of the drafters of the UETA, and then also incorporated into ESIGN, should absolutely be celebrated. So the autonomous transactions, smart contracts, all of that, automated transactions, there's different levels, and was considered and incorporated. In addition, the definition of an electronic signature and electronic record were also purposely drafted to be incredibly broad, to enable permanency, even though technology was going to continue to change. And what we've seen so far is there's been a number of states that have attempted to enact or amendments to revise the UETA to define blockchain, to define a smart contract, when, not only, and you said it is, not only is it not necessary, but it's going to, once again, cause confusion, lack of uniformity, and may not be technology neutral. So we through Ezra have been taking a fairly active role, along with the Uniform Law Commission, along with the Chamber of Digital Commerce and others, in trying to educate as many people as we can. Now that's, as we go forward, there may need to be amendments to underlying law. So not the UETA, not ESIGN, but underlying laws related to and regulating the transactions to enable certain aspects, either because the law needs to be updated, or because we need to make sure that confusion is eliminated and certainty is there, so companies can move forward. But in any event, it's really a testament to the UETA folks who really thought long and hard about how to make this uniform law lasting.
Right. And then along come EFT or NFTs, right? Non-fungible tokens, and the concept of digital assets, which was unfathomable, in 1999, but here we are, and the As you say, the predicate statutes are now being looked at, including by the ULC. And I think, David, you've got some interesting stuff to say about that.
Well, I have stuff to say. I won't guarantee it's interesting. And it may only be interesting to Uniform Law Commission and Uniform Commercial Code nerds, but it is an illustration of kind of the difference between ESIGN and UETA, which were written to be extraordinarily broad overlay statutes, and so already covered blockchain and smart contracts because the folks that actually wrote those statutes apparently had access to crystal balls when they did it. And they even to a certain extent anticipated digital assets in a couple specific instances. They created the transferable record, and they created through Article 9 of the Uniform Commercial Code, electronic chattel paper, recognizing that those particular kinds of property or contract rights only could continue to exist in an electronic environment if they were freely transferable without the transferees having to worry about intermediate claims by third parties. Well, in the course of doing that, the folks who drafted UETA and ESIGN left a lot of other things behind. And what they left behind were non-negotiable promissory notes in particular. And they also left behind any other kind of digital asset and didn't really include those in this free transferability concept that they were building. Essentially the advent of cryptocurrency, and now, as Ken says, non-fungible tokens or NFTs, or what the heck are these, as I know them most affectionately, are illustrating that the time has come to think seriously about expanding those kinds of assets that can be freely transferred without having to worry about intermediate claims, unless you have a particular kind of hold on those assets in the nature of what we called with transferable records control, that essentially takes the place of modern day possession, where you can be sure that you're the person with primary rights because you're holding the document that reifies the contract right in your hot little hands. And so the Uniform Law Commission has actually got in process, nearly 1 year into a 2-year drafting effort, a new article for the Uniform Commercial Code that they are tentatively at least calling Article 12. Apparently there's an Article 10 and 11 someplace, but nobody talks about them. It's kind of like the 10th and 11th amendments to the Constitution. Nobody talks about them much. Ironically, the 10th and 11th articles to the Uniform Commercial Code don't get talked about much either. Don't know why. In any event, in Article 12, the idea is that things that currently might be freely transferable if they were on paper will now be freely transferable in electronic environment. And to give you a concrete example, look at non-fungible tokens that represent a right to an NBA ticket from somebody's Final Four game. Now, these are big collectibles in the paper world. In the electronic world, of course, it's kind of frustrating because anybody can print up a ticket that looks like your ticket to the NCAA final where, Fred Morgenschnertz was, doing 25,000 baskets and in the course of a single game. But the idea then is if you have an NFT that represents the right to have the one considered original of that ticket, how can you transfer it? How can you sell it? Because of course, a lot of people don't really buy these because they want to just keep them. They buy them because they're collectible and valuable, and someday they'd like to transfer them. Transferees, on the other hand, are worried about the prospect that someone else may claim a superior interest. And right now, they can probably do that by just having filed a financing statement on the transferor's assets. And that means if you want to be sure you're getting the sole claim to that lovely ticket for a Fred Morgenschmertz 25,000 baskets, you have to go check the financing statements. No one wants to do that. It's long, it's expensive, it's boring, and what's more, most people can't read those reports when they come from the Secretary of State's office anyway. The Uniform Law Commission hopes to fix that. And they hope to fix it, ironically enough, by going back to the original conception for transferable record in the original draft of the UETA. And in the original draft of the UETA, there was no authoritative copy. All right, there was no control concept in the sense of you had to have some kind of very specific kind of process for maintaining control. The notion was if there was a reliable way to establish the party in control, that was good enough. And so Article 12 expands the universe of records so that it would include NFTs, it would include electronically evidenced non-negotiable promissory notes, which incidentally today could be transferred if they were on paper, free of intermediate claims as instruments for the most part under Article 9, but can't be transferred as transferable records because they're not otherwise negotiable. This has the opportunity to expand exponentially the number of freely available transferable assets that are out there in the marketplace, and to give folks who buy NFTs and non-negotiable promissory notes that are in electronic form a lot more comfort that they don't have to worry about that nasty old all assets filing financing statement that was filed 5 years ago against the prior owner of the property. And they don't have to worry about that secured party, or the secured parties are the bankruptcy trustee of the transferor showing up at a later date and saying, wait, what you got in that NFT actually belongs to me. Now, stay tuned. They aren't done yet. They're only halfway through the process. So there's still a lot of drafting to come, as the saying goes. But they have very, very good people working on the project who know exactly what they're doing. And of course, if nothing else, the Uniform Law Commission can be counted on to be deliberate, even as we observe in our ESIGN book, occasionally glacial. But they'll get to the right answer at the end of the day. Now, there are other things going on in the road ahead, and I'm not exactly sure which of the many folks on the panel are picking it up from here, but someone's going to start to talk about other things that are coming in the near future, that at least we think are coming in the near future.
As we do, it would be interesting to, especially on the question of authoritative copy, get Steve Bisbee's thoughts.
So one of the things that is really interesting is that David, as he said, is one of those nerds, but he's our nerd. And so he's one of the few people that understand that the safe harbor provisions, which were in UETA and then ended up in Article 9, ended up in ESIGN, they were not in the original draft of UETA. That was really as a result of concern from the Federal Reserve and others that they wanted to make sure there were criteria that were put into the statute. And so even today, if you go into either the ESIGN or UETA, there's a general provision, which is just as what David described, which would enable you to do the NFTs, as Ken said, those would be covered in terms of technology without having to meet the authoritative copy requirements for either of those statutes. What potential Article 12 is doing is not changing the need for control. It's coming back to the clearer, well, not clear, but the broader vision of what you actually have to establish. And so our concern from the original perspective is making sure, as you have always said, Jerry, when you're doing legislation, the first rule is do no harm. And making sure that it doesn't, what's happening with Article 12 doesn't in fact negate or in some way obviate the billions and billions of dollars that have been put out in the secondary market that really now represent 12–15% of all the securitization market, paper or digital today, by changing the rules of the road. So, but as Ken also said, 20 years is a long time. Technology changed. The whole purpose of these statutes were to be enabling, and we have to make sure they continue to be so.
And just to note that Article 12 does preserve or exclude transferable records and electronic chattel paper. So those provisions still live on and continue to exist. The idea is to expand the universe of transferability.
Right. Yeah, the safe harbor will continue to exist with respect to transferable record and electronic chattel paper. It's very likely that unless the ULC does something very different, you won't see much movement, for example, in the first residential mortgage market from transferable record to the new transfer of, they call it a controllable electronic record. Right now in Article 12 draft, you won't see much movement. And the reason you won't is because transferable record gives you one goodie that isn't coming along right now in Article 12, and that is freedom from defenses that would apply to a prior transferor. As a holder in due course of a negotiable promissory note, I don't have to worry about the fact that the last holder of negotiable promissory note did a nasty thing to you as the promisor on that note. That's not my problem in most cases, okay? And that is very different for negotiable promissory notes than most other kinds of debts. Well, that is preserved in the UETA and ESIGN. It's not in the controllable electronic record right now in Article 12. So you can expect the first residential mortgage market to not be enthused about moving to the new regimen. They're going to exist side by side. And in some cases, folks are probably going to have their choice. But I don't think you're going to see transferable record or electronic chattel paper go anywhere in the near future, so long as Margot says, the exceptions that are currently in the draft continue to exist. And I expect they will.
David and Steve, along those same lines, what impact, if any, does this movement towards an Article 12 solution have on the concept of vaulting, which really isn't in either statute? And where do we see that process going? I know it happens a lot in mortgage and also in other chattel paper transactions like auto finance.
I personally don't see, I don't see it changing much, except I think it may make vaulting more popular. And that's for two reasons. Number one, there is still the requirement to establish control, and control is very heavily defined in Article 12 and has to do with the right to being the sole party with the right to enforce, the sole party with the right to transfer ownership, okay? And e-vaults, of course, are an excellent mechanism for handling records of transfers of control. They are also an excellent method to establish record integrity. I like to call them data management on steroids. And I see the fact that the e-vaults have been so laser focused on making sure that they can establish the ongoing integrity of the records is going to continue to make them very, very valuable as you move into these new areas, especially for anyone who wants them essentially curated. You know, one of the things that people always talk about with blockchain is, oh, blockchain lets us disintermediate. We don't need a moderator. We don't need a curator. Everybody, Yahoo, we just all, link into the blockchain. It's been amazing the number of folks and the number of interests that have looked at that and gone, yeah, we don't think so. We like having a moderator. We like having a curator. Well, e-vaults really lend themselves to moderation and curation and the use of registries, where the registrar can actually, in a case of need, intervene if there's a problem. And so for myself, Steve may see it differently. I personally think we're not going anywhere e-vault wise, except maybe to have a bigger market.
Yeah.
So what could I say against that? Not much. but there is one aspect of it, and that David raised, the idea of registries, the idea of marketplaces, possibly the ability to exchanges, but they would all be sitting on an e-vault concept for the reasons that that David expressed, but also we're seeing, say, the more prevalence of fraud in order to be able to make sure there's security in the secondary market, that there's trust. And even those are the folks that are proselytizing now and using blockchain in financial services, they have the same concepts. They understand the value and the necessity of it. So I think there may be different types of e-vaults for different purposes, but they're going to be foundational in how digital transactions are managed.
Yeah. Chain of custody and the integrity of the record in the event of a dispute is what the eVaults solve for. So Steve, why don't we turn it to you?
So let's make sure here. I go off from you. So this, as we're closing today, one of the things that we wanted to talk about was Ken Moyle. Okay. And Ken has been a colleague and true friend for the four of us for 15 years. Ken's a leader in digital transformation enablement, including the legal, the business, and the technology. He has served as Chief Legal Counsel and Chief Policy Officer for DocuSign for 10 years and came to Ezra as a DocuSign representative and then board meeting. He continues as the chairman of the Ezra Public Policy Committee since its inception, leading and challenging us all to think deeper and do more. He continues to share his expertise through the founding of K6 Partners, the legal and consulting firm which he leads, that supports all types of digital consumer and business processes. And he supports numerous companies with his knowledge and guidance, including the original on the advisory board. So when we talk about ESIGN Day, National ESIGN Day, Ken was led the grassroots and legislative efforts to create National ESIGN Day that we celebrate, and with support of DocuSign and Ezra. So Ezra has given its Cornerstone Award to individuals who have made a fundamental impact on enabling digital transformation through their commitment and personal efforts. So Mallory, that's your cue. There you go. So this is the, Ken has seen these. Well, now he has one of his own. And it says on it, in recognition of your foundational vision and influential leadership in the advancement of electronic signatures and records, presented to Cornerstone Award, presented to Ken Moyle, 2021.
Hear, hear.
Hear, hear. So Ken, I want you to know that the Ezra members were unanimous in wishing that you receive this award. And we want to thank you for all you've done for Ezra and so many others, for never lacking in opinion or willingness to help. We are very grateful. Congratulations.
Thank you folks so much. I'm floored, and this panel, these folks that are surrounding me here today are some of the people that I respect, admire, and love the most in this whole industry. You've been friends, colleagues, and part of my personal board of directors for as long as I can remember now. It's been at least 15 years. And to have you surprise me like this is it's awesome. So I appreciate it. I look forward to any contributions that I can make towards this effort. We'll never be done. But we've come so far. So thank you so very much. Appreciate it. Happy ESIGN Day to everybody.
Thanks.
You'll be getting an NFT of that award.
I just wanted to observe, as Ezra as the ESIGN Act reaches its 21st birthday, it's now liberated. It's free to do what it wants, just like everyone else who turns 21. So who knows where it'll go from here.
ESIGN party.
All right.
Thank you very much, folks.
Thanks.
Thank you.
Thank you all.